Hey everybody, welcome to another episode of Classes of Mail. My name is Alan Gigax, and we are going to pick up reading the ELM where we left off. The next section is 514, Leave Without Pay. The plan for today is to get through the rest of the 500s of the ELM. We'll see. All right, 514, Leave Without Pay. 514.1, Essential Features. The following definitions apply for the purposes of 514. A. LWOP, just leave without pay. LWOP is an authorized absence from duty in a non-pay status. This is worth noting. Leave without pay is authorized. You are authorized to be off duty. It's different from AWOL, absent without leave. Oh, it actually says that in C. Maybe I should just keep reading. B. LWOP may be granted upon the employee's request and covers only those hours that the employee would normally work or for which the employee would normally be paid. C. LWOP is different from AWOL, absent without leave, which is a non-pay status due to a determination that no kind of leave can be granted, either because 1. The employee did not obtain advance authorization, or 2. The employee's request for leave was denied. 514.22, Administrative Discretion. Each request for LWOP is examined closely, and a decision is made based on the needs of the employee, the needs of the Postal Service, and the cost to the Postal Service. The granting of LWOP is a matter of administrative discretion and is not granted on the employee's demand except as provided in collective bargaining agreements or as follows. And there's a list of reasons that are all essentially military-related reasons. So it's up to management whether they want to grant you your leave without pay. You can ask, and if they're supposed to give thoughtful consideration to it. So if they're just denying it out of hand, that is not appropriate, and they should not be doing that. 514.23, Condition. In granting approval for extended LWOP, the granting official should have reasonable expectation that the employee will return at the end of the approved period. 514.24, Leave Credit Adjustment. Employees who are on LWOP for a period or periods totaling 80 hours during a leave year have their leave credits reduced by the amount of leave earned in one pay period. 514.25, Other Employment. LWOP is not granted for the purpose of enabling an employee to try out or accept other employment. So this brings up an interesting question because, I would love to go on a show like The Amazing Race or Survivor or something. And, you're gone for a month or 2 months at a time or however long it is. And I would take leave without pay for that, And does that count as other employment? I don't know. Maybe it does. Well, if I ever have to figure that out, then lucky me. All right. 514.4, Acceptable Reasons and Instructions. See Exhibit 514.4 for acceptable reasons and instructions for leave without pay. And then there's a big chart here, and I just picked out some of the more interesting reasons. Personal reasons. LWOP may be granted to cover the absence. If the employee has no leave to cover vacation during choice vacation period, LWOP may be granted to cover the absence. Full-time attendance at college or university. Restricted to full-time employees. An official transcript of courses taken must be submitted to the installation head. And personal illness or injury. An employee may utilize annual and or sick leave in conjunction with LWOP, subject to the approval of leave in accordance with normal leave approval procedures. An employee need not exhaust annual leave and or sick leave before requesting leave without pay. A medical document from the attending physician or practitioner must be obtained before approval, the same as for sick leave. Applications for LWOP to cover a period in excess of 30 days or in any 1 year, in excess of 30 days in any 1 year in case of illness or injury are reviewed and acted upon by the installation head. An employee normally will not be separated from the service because of absence due to personal illness or injury for a period of less than 1 year. An employee may be separated if required to be absent for more than 1 year unless there is cause to expect recovery and return within a reasonable time at the end of 1 year in LWOP status. The separation of an employee after 1 year of continued absence, with or without pay, does not prevent an eligible employee from filing an application for retirement. So essentially, if you need to take a whole bunch of time off, you can do that. And if you stay under a year, in theory, your job should be waiting for you when you come back. I know I've seen employees at my station who just disappear for long stretches of time. And I would imagine that this is part of the argument that the union uses is, hey, you can take leave for up to this amount of time as long as you're coming back. So I assume that's part of the argument, but I don't know. I don't have any experience with that. Next, injury on the job. It gets complicated if you're injured on the job. So if this is your situation that you're going to have to take extended leave because of an on-the-job injury, by all means check out 514.4. And at some point in the future, when I'm finally ready to learn about on-the-job injuries, I'll have to come back to this. And then there's a whole bunch of military reasons why you can also take leave without pay, and those are pretty much all granted. 514.5, forms required. 514.51, PS Form 3971. A request for LWOP is submitted by the employee on PS Form 3971. If the request for leave indicates that the LWOP work will extend for over 30 days, a written justification and statement of reason for the desired absence is required. So I guess that also means, by exception, that if it's for less than 30 days, you don't necessarily have to provide a written justification. 514.52, PS Form 50. PS Form 50, notification of personnel action, is prepared when LWOP is in excess of 30 days. Next, 515, absence for family care or illness of employee. 515.2, definitions. The following definitions apply for the purposes of absence for family care or illness of employee. Subparts A through C apply to leave for one's own or a family member's serious health condition. So your health condition or a family member's. A, son or daughter, biological, adopted, or foster child, stepchild, legal ward, or child who stands in the position of a son or daughter to the employee. In legal terms, by the way, that is called in loco parentis. So a child who stands in the position of a son or daughter to the employee who is under 18 years of age or who is 18 or older and incapable of self-care because of mental or physical disability. So this notation in here, this in loco parentis, that is important to a lot of employees because people have unconventional living situations. You know, not everybody is married. Not everybody has like the normal nuclear family structure. So much so that I don't think it's even reasonable to call that the normal structure because families are just so varied. And so it's possible that you have a boyfriend or girlfriend who you live with who has a child, and for all practical purposes, you are the parent to that child. And so in that case, this is the claim I would make, that I am in loco parentis, that I am the person who acts as the parent for this child, and therefore taking leave for that person is reasonable. B, parent. Biological, adoptive, step, or foster parent, or any individual who stood in that position to the employee when the employee was a child. So again, in loco parentis applies to you as the parent, and it also applies to your parent, or whoever was that person to you. And then the definition of spouse is husband or wife. And then next, there's a whole series of military relationships where they essentially just add of a service member to the definition. So there's all those also. And then we fall all the way down to part I, serious health condition, illness, injury, impairment, or physical or mental condition that involves any of the following. 1, hospital care. Inpatient care, such as an overnight stay in a hospital or residential medical care facility, including any period of incapacity or subsequent treatment in connection with or subsequent to such inpatient care. B, absence plus treatment. A period of incapacity of more than 3 consecutive full calendar days, including any subsequent treatment or period of incapacity relating to the same condition that also involves either of the following. A, treatment 2 or more times by a healthcare provider within 30 days of the first day of incapacity. B, treatment by a healthcare provider on at least one occasion within 7 days of the first day of incapacity that results in a regimen of continuing treatment under the supervision of the healthcare provider. And as a reminder, all of these are essentially definitions of absence types. Right? Let me go back up to the top and just make sure that that's what we're dealing with. Yeah, this is the These are the definitions of absence for family care or illness of employee. All right, moving on. 3, pregnancy. Any period of incapacity due to pregnancy or for prenatal care. And these are all Dude, a little peek behind the curtain here. When I take notes, I put, in addition to copying all the stuff out of the ELM onto my tablet that I think is relevant, I'll add little notes. And so I'm going through this and I'm reading it to you, and you just heard me go back and say, hey, remember, this is what we're talking about here. And right after pregnancy, I had actually written that note into my tablet that says, hey, make sure you remind people like what all these definitions are for. So, well, at least I'm consistent. I got that going for me. All right, number 4, chronic condition requiring treatments. A chronic condition that meets all of the 3 following conditions. A, requires periodic visits, i.e. at least twice a year, for treatment by a healthcare provider or by a nurse or physician's assistant under direct supervision of a healthcare provider. B, continues over an extended period of time, including recurring episodes of a single underlying condition. C, may cause episodic rather than a continuing period of incapacity. Examples of such conditions include diabetes, asthma, and epilepsy. 5, permanent or long-term condition requiring supervision. A period of incapacity that is permanent or long-term due to a condition for which treatment may not be effective. The employee or family member must be under the continuing supervision of, but not be receiving active treatment by a healthcare provider. Examples of such conditions include Alzheimer's, a severe stroke, and the terminal stages of a disease. 6, condition requiring multiple treatments, non-chronic condition. Any period of absence to receive multiple treatments, including any period of recovery therefrom, by a healthcare provider or by a provider of healthcare services under order of or referral by a healthcare provider, either for restorative surgery after an accident or other injury, or for a condition that would likely result in a period of incapacity of more than 3 consecutive full calendar days in the absence of medical intervention or treatment. Examples of such conditions include cancer, severe arthritis, and kidney disease. Note, cosmetic treatments, such as most treatments for orthodontia or acne, are not serious health conditions unless complications occur. Restorative dental surgery after an accident or removal of cancerous growths is a serious health condition, provided all other conditions are met. Allergies, substance abuse, and mental illness may be protected if all conditions are met. Routine preventative physical examinations are excluded. Also excluded as a regimen of continuing treatments are treatments that involve only over-the-counter medicine or activities such as bed rest that can be initiated without a visit to a healthcare provider. For example, treatment for substance abuse may be protected if provided by a healthcare provider or by a provider of healthcare services on referral of a healthcare provider. J, serious injury or illness. And then this section refers to injuries for service members that were incurred or aggravated while they were serving. So that's all covered under J. K, here's the definition for healthcare provider. A doctor of medicine or osteopathy, Christian Science practitioner listed with the First Church of Christ, scientist in Boston, Massachusetts, physician's assistant or other attending practitioners as defined by the Department of Labor FMLA regulations who are performing within the scope of their practice. And then we get to 515.4 leave requirements. 515.41 conditions. Eligible employees must be allowed a total of up to 12 work weeks of leave within a Postal Service year for one or more of the following. For incapacity due to pregnancy, prenatal medical care, or childbirth. B, to care for the employee's child after birth or placement for adoption or foster care. C, to care for the employee's spouse, son, or daughter, or parent who has a serious health condition. D, for a serious health condition that makes the employee unable to perform the employee's job. And E, because of a qualifying exigency arriving out of the fact that the employee's spouse, son, daughter, or parent is a military member on covered active duty in the armed forces. And if any of these conditions are military related, then the time gets extended to 26 weeks. 514.42 leave type. Absences that qualify as FMLA leave may be charged as annual leave, sick leave, continuation of pay, or leave without pay, or a combination of these. Leave is charged consistent with current leave policies and applicable collective bargaining agreements. 515.5 notice and documentation. 515.51 an employee must provide a supervisor a PS Form 3971 at least 30 days before the absence if the need for FMLA leave is foreseeable. If 30 days notice is not practicable, the employee must give notice as soon as practicable. When the leave is for planned medical treatment, the employee should first consult with the supervisor about the timing of the leave and must make a reasonable effort to schedule the treatment so as not to unduly disrupt the employer's operations. Oh, dude, for me, that's easy. Like if I ever need to go in for foot surgery, that's happening during the summer. I'm going to take the summer off so that I can have my surgery. And hopefully the supervisor cooperates with that. When the need is not foreseeable, notice should also be given as soon as practicable, i.e. the same day at least before the start of one's tour. During an absence, the employee must keep his or her supervisor informed of intentions to return to work and of status changes that could affect his or her ability to return to work. 515.52 documentation. In all cases, it is the employee's responsibility to provide complete and sufficient medical certification to establish a serious health condition as defined under the FMLA. Failure to provide complete and sufficient documentation may result in the denial of FMLA protection. And of course, if you've ever had to file FMLA, you know that happens all the time. That FMLA will just not accept your paperwork and they want you to redo it. And oh, dude, it's the pits. 515.532, care of others for medical reasons. So the requirements here are basically the same as for your own illnesses or injuries. Note, it reads, the medical certification provision that an employee is needed to care for a family member encompasses both physical and psychological care. It includes situations where, for example, because of a serious health condition, the family member is unable to care for his or her own basic medical, hygienic, or nutritional needs or safety, or is unable to transport him or herself to the doctor. This term also includes providing psychological comfort and reassurance that would be beneficial to a child, spouse, or parent with a serious health condition who is receiving inpatient or home care. 515.6, intermittent leave or reduced schedule. 515.61, new son or daughter. Absence is requested because of the birth and subsequent care of the employee's newborn son or daughter, or because of the placement of a son or daughter with the employee for adoption or foster care, may be taken on an intermittent basis or reduced work schedule only if the request for such intermittent leave or schedule modification is approved by the supervisor. Eligibility for this leave expires 1 year after the birth or placement. Approval is based on employee need, postal service need, and the cost to the postal service. 515.64, temporary change in duty assignment. If an employee requests intermittent leave or a reduced work schedule that is foreseeable based on planned medical treatment, the Postal Service may assign the employee with equivalent pay and benefits temporarily to the duties of another position consistent with applicable collective bargaining agreements and regulations if such an assignment better accommodates the recurring periods of absence. And then we move on to 516. All right, so that's it for FMLA. That's it for your sick leave definitions. Now we're going to 516, which is absences for court-related services. So that's one of the nice things about working at the post office. Like if you get called to jury duty, it's covered. And there are questions that I see posted online like, hey, I got called for jury service. If I get released early, what do I have to do? Well, we're going to cover all this. 516, absence for court-related services. 516.1, general. 516.11, determining nature of court-related service. Installation heads ascertain the exact nature of court service and determine if the employee, A, is entitled to paid court leave, B, must take annual leave or LWOP, or C, is to serve in an official duty status. If a summons to witness service is not specific or clear, the installation head contacts appropriate authorities to determine the party on whose behalf the witness service is to be rendered. When the exact nature of court service is determined, records are annotated accordingly. 516.2 Court leave. 516.21 definition. Court leave is the authorized absence from work status without loss or reduction in pay, leave to which otherwise entitled, credit for time or service, or performance rating. So just to be clear, court leave is an authorized absence where you don't lose any of those things. Of an employee who is summoned in connection with a judicial proceeding by a court or authority responsible for the conduct of that proceeding to serve as a juror, as a witness in a non-official capacity on behalf of a state or local government, or as a witness in a non-official capacity on behalf of a private party in a judicial proceeding to which the Postal Service is a party or the real party in interest. The court of judicial proceeding may be located it lists all these different places that are part of the United States. So if you get summoned to be a juror or to be a witness on behalf of the government, or if the post office is involved, all of those ones are covered under definition. Next, 516.22 eligibility. Court leave is granted to full-time and part-time regular employees. Certain part-time flexible employees are granted court leave as provided and governed by applicable collective bargaining agreements. Other employees are ineligible for court leave and must use either annual leave or LWOP to cover the period of absence from postal duties for court service, but may retain any fees or compensation received incident to such court service. So that makes me wonder, do CCAs not get court leave? It seems like they do. Maybe it's covered in our collective bargaining agreement. If you know where that is off the top of your head, feel free to send it to me, or if you're familiar with that situation. But yeah, according to this, 516.22, CCAs would not get paid for court leave. Court leave is granted only to eligible employees who would be in work status or on annual leave, except for jury duty or service as a witness in a non-official, serving as a witness from the definitions above. An employee on LWOP, when called for such court service, although otherwise eligible for court leave, is not granted court leave, but may retain any fees or compensation received incident to court service. So essentially, if the post office would be paying you that day, then the post office will pay you that day. If the post office would not be paying you that day, then they won't pay you that day. 516.3, conditions affecting court-related service. 516.31, employee on annual leave. If an eligible employee while on annual leave is summoned for court service that qualifies for court leave or official duty, the employee's annual leave is canceled and the employee is placed on court leave or official duty for the duration of such court service. Employees who are not entitled to court leave or official duty must use annual leave or LWOP for the period of absence from duty for such court service. 516.32, combination of court leave and postal duty. The following provisions concern combinations of court service and postal duty. A, employees who report for court service and are excused early. There you go. This is what we promised we'd talk about. If an employee reports for court service and is excused by the court for the balance of the day, or performs court service for only part of that day, the employee is entitled to full compensation for the day in question. An employee who would otherwise be in a work status is required to report to the postal installation for the balance of the postal tour of duty, provided 1, an appreciable time of the tour is involved, and 2, it is feasible to report to work and complete the tour. Combined paid court leave and postal duty may not exceed 8 hours. All right, so just recapping here, it's definitely going to be an 8-hour day for you. And if you get off early enough that it's practical to come to work and complete the day, then you come back to work and complete the day. B, employees who serve a full day in court. Employees serving a full day in court service are not required to report for their postal duties. And C, employees excused from court service for an extended period. Employees, including rural carriers who are excused from court service for an entire day or days, are not entitled to compensation for such days unless they actually perform service as postal employees. So, for example, you get summoned to serve on a jury, and you get selected, you're on the jury, and then court adjourns for a couple of days because they're going to negotiate a plea deal or whatever the reasons might be. You got to come back to work for those days. They're not going to pay you for court leave when court's not in session. No overtime is allowed for court service performed while an employee is on court leave or for a combination of postal work and such court service. 516.4 Fees. 516.41 General. Employees may retain any court allowance in the amount of $25 or less per day on days court leave is authorized. Employees must remit to their supervisor amounts received in excess of $25 per day. Employees who are eligible to receive such fees are not authorized to waive the fee. So, if court service pays you, you keep that money. But if it's more than $25, you have to give the surplus to your supervisor. And again, this goes in conjunction with what we learned earlier, that's if the post office is already paying you. If the post office is not paying you, you keep all that money. 516.42 Court service outside of regular working hours or regular working days. Employees who perform court service outside of their basic work week, like scheduled days off, or outside of the scheduled tour of duty for which no court leave is granted, may accept and retain the jury or witness fees or payment received incidental to such court service. So once again, this is a reiteration of that basic idea that if the post office is paying you, then the post office pays you, and if they're not, whatever money you get from the court, you keep. 516.43 Holidays. Fees received for court service falling on a holiday within an employee's basic work week may be retained by the employee, provided the employee would have been excused from regular postal duties on the holiday. 516.44 Annual Leave or LWOP. Employees who are on annual leave and do not change or are not eligible to change the annual leave to court leave, or who are on LWOP for court service, may retain fees or payment received incidental to such service. 516.6 Witness service in a non-official capacity on behalf of a private party. An employee who is summoned to testify in a non-official capacity, like as a private individual, on behalf of a private party is not performing official duty. The employee's absence is charged to court leave if the testimony is given in a judicial proceeding to which the Postal Service is a party or the real party in interest. If the Postal Service is not a party or the real party in interest, the employee's absence is charged to annual leave or LWOP. So if you have to go to court as a mailman, then yeah, the post office is going to pay you for that. But if you're going to court because somebody was in an auto accident and you're a witness, post office isn't going to pay you for that. So you may want to get with that attorney and ask if they'll pay you to be a witness. I don't really know how that stuff works. Then there's the next section in this part of the ELM that covers paid military leave. And if you're concerned about how your military leave pay works, you probably already know. If you're in the military, you're probably already well familiar with these provisions. But if you're not, check out section 517. Next, 519, administrative leave. 519.1, definition. Administrative leave is absence from duty authorized by appropriate postal officials without charge to annual or sick leave and without loss of pay. So it's just essentially another type of leave that puts you in a pay status. 519.2, special conditions. 519.21, acts of God. 519.211, general. Acts of God involve community disasters such as fire, flood, or storms. The disaster situation must be general rather than personal in scope and impact. It must prevent groups of employees from working or reporting to work. So examples of this would be, well, it says fire, flood, storms. So, there's a blizzard and you can't get to work, stuff like that. 519.212, authorizing administrative leave for acts of God. The following provisions concern administrative leave for acts of God. A. Postmasters and other installation heads have authority to approve administrative leave for up to 1 day. B. District managers and Postal Career Executive Service plant managers may authorize administrative leave beyond 1 day, but not to exceed a total of 3 days for their installation and those reporting to it. C. District managers and senior or lead plant managers may approve administrative leave for periods up to and is in excess of 3 days for their installation and those reporting to it. 519.213, determining the cause of absence. Postmasters and other appropriate postal officials determine whether absences from duty allegedly due to acts of God were in fact due to such cause or whether the employee or employees in question could, with reasonable diligence, have reported for duty. Yeah, man, you should have taken your canoe to work or your snowmobile to work, slacker. 519.214, early dismissal due to acts of God. When employees are dismissed from duty before the normal completion of their duty due to an act of God, the following applies. A. Full-time employees are entitled to credit for hours worked plus enough administrative leave to cover their tour of duty. This combination of work and leave should not exceed 8 hours in any one day. B. Part-time regular employees are entitled to credit for hours worked plus enough administrative leave to complete their scheduled hours of duty. This combination of work and leave is not to exceed 8 hours in any one day. C. Part-time flexible employees are entitled to credit for hours worked plus enough administrative leave to complete their scheduled tour. And again, that doesn't exceed 8 hours. If there's a question as to the scheduled work hours, the part-time flexible employee is entitled to the greater of the following. 1. The number of hours the part-time flexible worked on the same service day in the previous service week. 2. The number of hours the part-time flexible was scheduled to work. Or 3. The guaranteed hours as provided in the applicable national agreement. 519.215, employees prevented from reporting. Employees scheduled to report who are prevented from reporting or who, after reporting, are prevented from working by an act of God may be excused as follows. A. Full-time and part-time regular employees receive administrative leave to cover their scheduled tour of duty not to exceed 8 hours. B. Part-time flexible employees receive administrative leave subject to the 8-hour limitation for their scheduled work hours as provided up earlier. 519.216, employees on annual leave, sick leave, or LWOP. Employees on annual leave, sick leave, or LWOP remain in such status they are not entitled to administrative leave for acts of God. 519.22, civil disorders. The rules for this are essentially the same as the rules for acts of God. The postmaster or installation head determines if civil disorder is enough to keep you from coming to work. 519.3, civil participation. 519.31, state and local civil defense programs. 519.311, no charge to leave. Full-time employees who volunteer and are selected by state or local authorities for civil defense assignments are authorized to participate in pre-emergency training programs and test exercises conducted by their state or local government. Participation in these activities during the employee's regularly scheduled tour of duty cannot exceed more than 40 hours of administrative leave in any one leave year. And next we have 519.323, voting. The following provisions concern time allowed for voting. Look at this, like it's ripped right from today's headlines, right? When I'm recording this, here in Nevada, we're having our primary elections going on right now. And then, of course, there will be national voting this coming November. And these are the rules about taking time off for voting. A, 3-hour rule. As a general rule, if the polls are not open at least 3 hours before or after an employee's scheduled hours of work, the employee may be excused for the length of time that permits them to report for work 3 hours after the polls open or to leave for work 3 hours before the poll close, whichever requires the lesser amount of time off. Exception to the 3-hour rule. Under exceptional circumstances, if the general rule in 519.323A does not permit sufficient time, an employee may be excused for additional time needed to vote. However, time off must not exceed a full day. C. Charge to annual leave or LWOP. If an employee's voting place is beyond normal commuting distance, and if voting by absentee ballot is not permitted, employees may be granted sufficient time off to be able to make the trip to the voting place to cast their ballots. When more than 1 day is required to make the trip to the voting place, postal officials observe a liberal policy in granting necessary time off for this purpose. Time off in excess of 1 day is charged to annual leave, or if annual leave is exhausted or the employee so requests, it is charged to leave without pay. 519.325, restrictions. An employee is not allowed administrative leave for voting or registration during a period of absence on sick leave, annual leave, or leave without pay. 519.331, absence of veterans to attend funeral services. So here's another type of absence for which you would get administrative leave. Full-time Postal Service employees, except rural carriers. I wonder why they get accepted. Well, who cares? who are veterans of any war, campaign, or expedition, or who are members of honor of ceremonial groups or organizations of such veterans may be granted administrative leave not to exceed 4 hours in any one day to permit or to participate in funeral ceremonies for members of the armed forces of the United States whose remains are returned from abroad for final interment in the United States. Such participation is limited to service as active pallbearers or members of firing squads or guards of honor. Absences in excess of 4 hours in any one day are charged to annual leave or LWOP. 519.332, funeral of immediate relatives who died in combat zone. Administrative leave not to exceed 3 days is granted to employees to make arrangements for or to attend the funeral of or memorial service for an immediate relative who died as a result of wounds, disease, or injury incurred while serving as a member of the armed forces of the United States in a combat zone. Next, 519.4, National Day of Observance. 519.41, General. In the event that the Postmaster General or designee determines that the Postal Service will participate in a National Day of Observance, for example, National Day of Mourning, like when a president dies, subsequent to the declaration of a National Day of Observance by executive order of the President of the United States, administrative leave is granted to employees. So we get essentially an extra day off so that we can mourn the loss of the president, so we get paid 8 hours of administrative leave. 519.425, employees on paid leave. Employees on paid leave on the National Day of Observance receive administrative leave on that day in lieu of requested leave for up to the number of hours equal to the employee's regular workday. And I want to point out here that it's paid leave. It doesn't say annual leave, it's paid leave. So that would be annual leave or sick leave, because those are both types of paid leave. 519.427, employees absent without leave, suspended, or pending removal. Employees absent without leave, suspended, or pending removal on the National Day of Observance are not granted administrative leave. Note, an employee returned to duty and made whole for a period of AWOL suspension or removal may be eligible for administrative leave for the National Day of Observance, consistent with the rules of the provision 519.4 for that employee's group if the period of suspension or removal for which the employee is considered to have been made whole includes that day. Next, you get time off for medical events, 519.5. 519.51 is blood donations. 519.511 policy. All postal employees are urged to cooperate fully with the public blood donation program for the health and security of their community. The time necessary includes the time required for travel and the time required for the medical facility to process the blood donations. 519.512, time allowed. The following provisions concern time allowed for blood donations. 8. General allowance. Postal employees may be excused for that period of time deemed reasonably necessary to cover any absence from regular tours of duty to make voluntary blood donations without remuneration, which means you don't get paid, to the Red Cross, the community, or other nonprofit blood bank. So just to be clear about the remuneration, if you go to donate blood to a place that gives you $100 to donate blood, then no, this does not apply. This is for donating blood to like a charitable organization. This regulation does not apply to those employees who participate in this program on their own time off duty. Boy, you'd have to be a sucker to do that, right? If the post office is going to pay you to do it. B, additional time. In the case of employees in occupations for which the blood bank recommends additional time off following the blood donation, the time necessary includes the additional time recommended by the blood bank. Every effort should be made to have blood donations for such employees scheduled near the end of their tour of duty. 519.52, bone marrow, stem cell, blood platelet, and organ donations. 519.521, policy. Career postal employees who wish to donate bone marrow, stem cells, blood platelets, or organs may be granted administrative leave subject to the limitations that we're about to read with appropriate management approval. Administrative leave is not available to bone marrow or organ recipients. Next, 519.522, time limitations. Except as otherwise specified in the collective bargaining agreements, the maximum administrative leave that can be granted per leave year to cover qualification and donation is limited to the following. For a full-time employee, for bone marrow, 3 days. For stem cells, 3 days. For blood platelets, 3 days. And for organs, 14 days. And if you're a part-time career employee, it's the same time allotments, but they're cut in half. So like for organs, you only get 7 days. 519.54, first aid examination and treatment for on-the-job injury or illness. So if you get hurt on the job and you wind up needing treatment or examination, that's what this is about. 519.54, and we're going to end with this section. 519.541, employee on regular tour. If an employee on a regular tour of duty is injured or becomes ill and the illness or injury can be treated so that the employee can return to duty during that tour, the employee is excused without charge to annual or sick leave. The employee is not required to clock out when leaving the place of duty for first aid examination or treatment. So just to be clear, let's say you get a really bad paper cut and you have to have stitches. That'd be a hell of a paper cut. But after you get the stitches, you can come back to work. So, this happens at 10 a.m. You go to the quick care. They stitch you right up. You come back at noon. So those 2 hours that you were gone are not deducted from your pay. You stay in pay status. 519.542, employee in overtime status. When an employee is directed by management to an on or off-site medical unit due to illness or injury, all time spent waiting for and or receiving medical attention on the service day on which the illness or injury occurs, which would have been worked but for the medical attention, is credited as work time even though overtime hours may be involved. The employee's time card is so noted and initialed by the supervisor. So there you go. Even if you're on overtime, you still get paid for that time. 519.55, day of death. If an employee dies during a scheduled workday, which is obviously not unprecedented, the balance of the full tour is charged to administrative leave. Oh, look at that. They don't clock you out early if you die while you're at work. Thank goodness. If the employee dies before a scheduled tour begins, the full tour is charged to administrative leave, provided the employee was in a pay status, either work hours or paid leave on the last scheduled day before the day of death. When a scheduled tour overlaps a calendar day and begins at or near the previous day, a death occurring within 2 hours of the beginning of tour is considered to be before the scheduled tour, and the full tour is charged to administrative leave. All right, so there's more to go. There's more about benefits. You know what? This last section is pretty short, and that'll end the 500s. So screw it. I'm going to go for it. All right, 530, life insurance. Buckle down. We got a little bit more to go. 531.2, eligible employees. All postal employees except those specifically excluded in 531.3 or those who waive coverage receive basic life insurance coverage. Entitlement to basic life coverage qualifies them to elect optional life insurance coverage. And pro tip here, CCAs do not get life insurance. 532, coverage. 532.1, based on pay. 532.11, full-time employees. Full-time employees are covered by an amount of basic insurance and an equivalent amount of accidental death and dismemberment insurance based on their annual basic pay in effect at the end of any given pay period. The insurance of an employee who dies while serving in a higher level position is based on the basic pay of the higher level position. Basic pay for insurance purposes excludes such additional pay as overtime pay, holiday pay, etc. 532.12, part-time employees. Employees who are paid at other than an annual rate are covered by an amount of basic insurance based on an annual rate determined as follows. Part-time regular. The annual basic pay of the part-time regular schedule employees is computed by multiplying the basic hourly rate of pay for their levels and steps by the number of scheduled hours of service in a 52-week work year. And part-time flexible, the annual basic pay of part-time flexible schedule employees is computed by multiplying the basic hourly rate of pay for their level and step by 2,000 hours. 532.2, amount. 532.21, basic insurance. 532.212, maximum. If annual basic pay is more than $8,000, employees are insured for an amount equal to the sum of annual basic pay rounded to the next higher thousand, plus $2,000, plus an equivalent amount of accidental death and dismemberment insurance. So if your base pay is $50,000, then that's how much life insurance you have, plus $2,000. So it'd be $52,000 plus $52,000 of accidental death and dismemberment. Next, 532.213, extra benefit. The extra benefit doubles the amount of basic life insurance payable if the employee is age 35 or younger. Beginning on the employee's 36th birthday, the extra benefit decreases 10% each year until at age 45, there is no extra benefit. So if you're going to die while you're employed at the Postal Service, try to do it before you turn 45. 532.215, accidental dismemberment provision. The following outlines coverage under the accidental dismemberment provision. A. Allowance. The accidental dismemberment provision allows for insurance payment for loss resulting from bodily injuries incurred solely through violent, external, and accidental means, provided the loss occurs within 90 days after the date of the accident. B. Disallowance. The accidental dismemberment provision does not allow insurance payment for bodily injuries attributed to the following causes. 1. Disease or bodily or mental infirmity, medical or surgical treatment or diagnosis thereof. 2. Ptomaine or bacterial infection except for septic infection from a visible wound sustained through violent external and accidental means. 3. Hernia, no matter how sustained. And again, these are ones that it doesn't cover. 4. Bodily injuries sustained during A. Armed aggression or insurrection. B. War declared or undeclared. C. Any act of war. And D. Any aggression by armed forces against the United States in which nuclear weapons are being used. Yeah, sorry, man. You lose an arm in a nuclear attack. Post office ain't going to cover you for that. A bunch of jerks. Maybe we can negotiate for that in an upcoming national agreement, right? I want to be covered in the event of nuclear war. 5. Intentional self-destruction or intentionally self-inflicted injury while sane or insane. And 6. Self-administration of illegal or illegally obtained drugs. C. Amount of payment. The amount of accidental dismemberment payment depends on 1. The amount for which an employee is insured on the date the accident occurs, and 2. The extent of the loss. The maximum for any one accident is 100%. So there's a chart here, and basically if you lose 1 of something, it's 50%, 2 of something, it's 100%. So if you lose 1 arm, you get 50% coverage. If you lose 1 arm and 1 leg, you get 100%. So that's how that works. 534.4, living benefits. Employees with written documentation of a medical prognosis of terminal illness maybe I should have quit earlier. Employees with written documentation of a medical prognosis of terminal illness indicating life expectancy that does not exceed 9 months, are eligible to elect a lump sum payment of life insurance equal to or less than the value of their basic life insurance. This option is not available for additional optional insurance elections. So if you're about to die, you have this terminal prognosis, you can get your life insurance before you die. Section 540 covers the injury compensation program, and again, that's going to have to wait until I'm ready to learn about it. There's other sections in the 500s that cover unemployment insurance. Generally, that's handled by the states, similar to other jobs, like you have to go to your state office of unemployment. And important to note, you can't file a claim if you quit. You have to get fired or laid off or whatever to get unemployment insurance. And then there's more in the 500s that cover retirement plans. So if you're ready to retire, my suggestion is you talk to one of the experts in retirement and make sure that you are dialed in for that. All right, and then finally we get to 597.3, in-service withdrawals. 597.31, type of withdrawal. In-service withdrawals are thank God this is the last one. In-service withdrawals provide employees with an opportunity to withdraw funds from their TSP account while still employed, including employees in non-pay status. 2 types of in-service withdrawals are available. A. Age-based withdrawal. This allows employees who are 59 and a half or older an option to withdraw all or a portion of their vested account balance. B, financial hardship withdrawal. This allows employees, regardless of age, who demonstrate financial hardship caused by covered events, an opportunity to withdraw their own contributions and the earnings on those contributions up to the amount of the documented hardship. And thus ends the 500s. And yeah, I probably should have stopped earlier. But we got through it. We're good. Up next is going to be the 600s, which covers employee relations. So that's an interesting one. I've already got a bunch of notes on that going forward. So thank you guys for listening, and I will catch you next time.